The Supreme Court heard arguments today over whether or not former President Trump is eligible to be on the primary ballot in Colorado. Colorado's Supreme Court kicked him off the ballot, at least temporarily, citing the so-called insurrection clause of the 14th Amendment. It's Section 3 of the 14th Amendment, which says in part, no person shall hold any office who, having previously taken an oath to support the Constitution, shall have engaged in insurrection, unquote. Derek Muller is a professor of law at Notre Dame Law School, and Lawrence Lessig is a professor at Harvard Law School. Both join me now. Professors, I'm indebted to you both for being with us. I want to start with you, Professor Muller, and then go to you, Professor Lessig. If you were to summarize for a law school class in 40 seconds or less the most important component of today's oral arguments, Professor Muller, what would you say?
I'd say the Supreme Court was skeptical that one state could judge the qualifications of a candidate like this in a way that could affect all 50 states. The court seemed very skeptical that one trial court in Colorado could make this decision under Colorado rules of evidence, and that we might have inconsistent verdicts around the country, and that we might ask the Supreme Court to step in and clean up this mess if there are inconsistent verdicts. So the court was very concerned about one state affecting the national interest, and also about asking the Supreme Court to have to step in and resolve these disputes in the future.
Professor Lessig, your summary for your class.
Yeah, I would agree with that. I would also emphasize that the court was keen to see Congress play a role in specifying the procedures by which this issue could be adjudicated. I think the court recognized how complicated it was, and it pointed back to the historical times when Congress actually provided a remedy under the 1870 Enforcement Act that would enable you to remove somebody because they've been found to be an insurrectionist. And I think that's an appropriate place for the procedures to be set, and there's no such procedures that could be invoked here because President Trump has not been criminally prosecuted for insurrection.
And Professor Lessig, I know this is something that you have paid very close attention to, Congress's role in this, whether Congress has or hasn't involved itself in application of the 14th Amendment. Tease that out a little bit more for our audience, if you please, be so kind.
Well, we typically look at the Constitution and think it's obvious that a court can just invoke the Constitution and enforce it, which is why Colorado thought it was obvious that it could just invoke the Constitution to enforce it against President Trump. But the 14th Amendment is a complicated amendment. And some of the provisions, like Section 3, the provision at issue here, and Section 2, which is about apportionment if male voters are denied the right to vote, are very complicated to figure out how they might be enforced appropriately. And what the courts have done is say, in that kind of context, we're going to rely on Congress to take the lead or to set the framework before we're going to allow the provision to be enforced against particular people. And I think that makes sense in a context where there are so many questions about how you determine whether someone is engaged in insurrection, what kind of proof there is, what's the process. Those things should not be made up ad hoc by state courts or, frankly, any courts without the guidance from Congress.
Professor Muller, it was the consensus after the oral arguments concluded that the justices did not appear much interested in deciding or burrowing into the question of whether or not the former president engaged in or incited an insurrection. Did that in any way surprise you?
It wasn't that surprising in the sense that I think the Supreme Court wants to stay as far away from politics as possible and stay as far away from some of these contested factual issues as possible. So questions about whether or not Trump engaged in insurrection, getting at his state of mind on January 6th, getting at the meaning of his tweets, interpreting the content of his speech at the ellipse. That was something I think the court wanted to stay as far away from as possible. And given how many complex legal issues are at stake in this case and how many different directions that it could go, I don't think it's a surprise that the court chose not to spend much time on January 6th itself and spend much more time on text, history, and law.
Professor Lessig, I have read some of the amicus briefs, meaning friend of the court briefs, supporting what Colorado did. And one of the takeaways I have from those briefs is it's plainly evident that there was an attempt by the former president to block the peaceful transfer of power. By any common understanding, that is insurrectionist-like behavior. It is an assault on the former on the form of government of our country, and therefore this should be an open and shut case. Clearly, that's not what the court thought. What are your reactions to those who make that kind of argument?
Look, I completely agree that the behavior on January 6th was outrageous. And I think it's a sufficient reason to say he should not be president again. But whether it translates into a legal remedy to kick him off the ballot is a more complicated question. And I think the appropriate view, which I think the court affirmed looking at early jurisprudence that set the pattern of congressional responsibility here, suggests that if you're going to use the courts to kick people off, it's going to be through the structure of a statutory remedy that's been set by Congress. And Congress, for reasons that nobody seemed to know, dropped the most important remedy in the 1940s. So we basically only have a criminal remedy, and that wasn't used in this case. And so that means that as outrageous as his behavior was, and it clearly was, the real question is whether the law gives people the ability to kick him off the ballot. And as the law stands now, without criminally prosecuting him, the answer is no.
Professor Muller, if you engage in any basic civics lesson about the Constitution, you are familiarized with Article 2, and that was made reference to by the attorney representing Colorado, that it is Colorado exercising its Article 2 rights, time, manner, and place to supervise elections and eligibility. This is an eligibility question, clearly within the purview of Colorado, and it was exercising its rights in that regard. What's your answer to that particular contention?
Yeah, I think the court agreed that the state can set some rules for elections. The state can determine who's on the ballot. We know that not all the same candidates appear on the ballot in every state. The Green Party or the Libertarian Party might not be on the ballot in every state. But the court bristled here at the fact that Section 3 seems different, and especially when it's contested qualifications. In other places, if you're dealing with a 21-year-old or a Nicaraguan national, those are candidates who are ineligible to serve as president, keeping them off. But the court kept circling around this notion that there's something about Section 3 of the 14th Amendment that requires Congress to provide the enforcement authority. And so while it's true that Article 2 gives states a lot of power to come up with a manner of appointing presidential electors, to develop the ballot and include candidates, and maybe even keep certain candidates off, Section 3 feels different in kind, and it feels different in the sense that there are these contested factual disputes, and one state shouldn't be the one to make that decision for the rest of the country without Congress stepping in to provide some guidance about how they do that.
Coming to us from two of the finest law schools in our country, Professor Derek Muller, Notre Dame Law School, Professor Lawrence Lessig, Harvard Law School. I'm indebted to you both. Thank you so much.